Court of Justice, Original Jurisdiction, hearing of original application in BZOJ number 1 of 2020 between the State of Belize and the State of Trinidad and Tobago. This matter is being heard by the full bench of the court as follows. Mr. Justice Saunders, President and the presiding judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, all.
Mr. Justice Anderson.
Good morning, all.
Madam Justice Rajnauth-Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamadar.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please you, Your Honor. Andrew Marshalleck, together with Mrs. Samantha Matute-Tucker for the claimant.
Should it please the court in this matter, my lords, my lady, my name is Terrence Bharath for the purposes of the record. And appearing with me is Coreen, Findley, and Sasha Sukhram. And we are instructed by Miss Amrita Ramsook.
Okay, thank you. Good morning again. Mr. Bharath, do you still maintain any objection to the on reduction, the totals in the...
No, my lord. So if you choose, may I just say so, if you want the evidence from the witness, Mr. Huggins, we have him patched in. If you want it from the bar table and my learned friend will accept it, I can call the number.
Okay. We can... I know that some unredacted copies had been sent to your side, Mr. Marshalleck. Do you have those totals unredacted?
No, I'm not aware of that.
I see. Okay. Well, Mr. Bharath, you can simply read them out for Mr. Marshalleck.
Yes, yes, Mr. President. So the amount is 2,591.9498 tons. 2,591.498 tons. And that is a combination of Honduras and Guatemala for the period for the year 2019.
Mr. Bharath, are you going to give us the totals for 2018 broken down into the Guatemala total and the Honduras total, and then the total for 2019 as similarly? And then I think according to the documentation I have, there is also a total for 2020 Guatemala, Honduras. So three totals. Broken into a total for Honduras, a total for Guatemala for those 3 years?
Yesterday we were asked for 2019, so we had compiled overnight 2019. If you want 18 and 20, we will have to do that for you.
Yeah, Mr. Barrett, they are actually stated on the document, you know, you don't have to compile them. For 2018, the Guatemala total is 686.50.
But that's it. That's in kilograms, my lord. Kilograms.
That's kilograms, yes.
Not metric tons, yeah.
1 metric ton is 1,000 kilograms, correct?
Yes, you just divide by 1,000.
So exactly, that it would be 664.686 thousand.
Apart from that, Mr. Bharath, on the last 2 pages of the schedule that was redacted,
yes,
the penultimate page will gives the Guatemala total.
It has not.
And the net weight, if you look at that,
This is the one which redacted. No, this is not redacted. No, it's Justice Witt, did you say redacted or unredacted?
well, of course, I can read it on the unredacted one, but it's page 8 of this document. It gives the Guatemala total.
I have the Honduras total on page 9.
Yes.
And I have the
Guatemala total is on page 8, Mr. Bharath.
well, my lord, I do apologize. I'm not seeing that on mine.
If you, it's 1, 2, 3, the 4th row.
Oh yes, I see it, my lord. I see it.
Yeah.
I see it. I see it. Yes, thank you.
So if you can, so I suppose that is the total, the Guatemala total for the whole period.
Well, no, that looks from January 01 to June 30th, 2020.
Yeah.
Okay.
Because we wouldn't go beyond June 2020 when this was filed.
Yes. And can you mention that total weight?
The total weight that I see here for that period, January 1st to June 30th, 2020, is it's 2239,580.00. That's kilograms.
That's 2,239,580 kilograms divided by 1,000, right?
Yes, so that would be 2,239.58 tons. Am I correct?
Tons.
Metric tons, yes.
Correct. And then on page 9, the total for Honduras.
So the total for Honduras from January 1st to June 30th, 2020 is 1,178,684.
Which would be 1178 metric tons.
0.6.
Yeah.
0.68, sorry.
Yes,
Yeah.
0.684. Okay. So those are the totals that we have in this document.
So do you have all the totals, the relevant totals, Mr. Marshalleck? For 2018, 2019, 2020 up to June?
It goes from November to December.
Yes, I believe so. The only one I'm not showing is 2018 Honduras.
So in respect of 2018, if I may, with your permission, Mr. President, in respect of 2018, the claim or the allegations began in November of 2018. So we have November 1st, 2018 to December 31st, 2018, 116,482.50 for Honduras.
That's kilograms, is 116.
That's kilograms, so it'd be like a ton, 1.16 tons.
1 ton.
No,
1116 tons, yes, 1116 tons.
No, 116.48.
Yeah, there is no.
Yes, 116, I do beg your pardon. And for Guatemala, we gave that figure already, I think, or I don't know if I did, but if I didn't, it's 664.68,
Yes.
which is it's less than a ton, a metric ton.
That's for the 2-month period, November 1st to December 31st, right?
That is correct, my lord.
Yeah.
Mr. Barrow, just repeat, please, the Honduras figure.
Honduras, my lady, would be 116,482.50 kilograms. And in metric tons, it would be 116, help me,
0.482.
8.48. 0.48.
Thank
Yes.
you very much. Right, thank you.
116.
Okay, I take it that we can proceed now.
Yes, sir. Could I ask Mr. President, Mr. Huggins be relieved? I think he's still on.
Yes. Well, we wouldn't need him now. If we do, we will let you know, but not for the purpose of having this evidence unredacted.
Thank you, sir.
So your next witness is Ms. Lewis.
Yes, sir. I think Miss Lewis is if you just forgive me, I switched gears and misplaced my witness statements. Yes, Trudy Lewis. So I call Trudy Lewis. Miss Lewis, may I ask that you unmute your mic, please?
Hello, good morning.
Good morning.
Lewis.
I think you'll have to go on.
Can someone administer the oath?
Certainly. Good morning, Ms. Lewis.
Good morning.
Could you please raise your right hand? Do you swear by the Holy Bible that you will speak the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Good morning. Your name, ma'am, is Trudy Lewis,
Yes, it is.
and you are the Assistant Director, Trade Promotion and Development at the Ministry of Trade and Tourism in Trinidad.
I'm the Acting Assistant Director, Trade Development and Promotion in the Ministry of Trinidad and Tobago. Yes.
Right? And where do you live, madam?
I live at number 34 Agate Drive, Diamond Vale, Digger Mountain.
Thank you. And madam, do you recall making a witness statement in these proceedings dated 18th May 2021?
Yes, I do.
Do you have that witness statement in front of you with the exhibits?
Yes, I do.
Could you turn that witness statement to the page on which your signature appears, please, which is at page 748? Can
Yes.
you push it closer to the screen so their lordships and ladyship could see it, please? Thank you. Madam, could you identify your signature on that document, please, as being yours? No, could you look at the signature and identify it as being yours?
Yes, it is my signature.
And the facts contained in this witness statement are true and correct?
Yes.
Thank you. Mr. President, may I beg to tender this document as TL? And
Yes.
may I also offer this witness for cross-examination?
Yes, the document is admitted as TL, and Mr. Marshalleck, you may cross-examine the witness.
Right, Your Honor. Ms. Lewis, at paragraph 6 of your witness statement, that's page 737, you described the claim of the claimant, and you said at the foot thereof that you say at the onset that I have seen no documents to support such a claim. You remember making that statement?
Yes, I do.
Well, I want to ask if you've looked for any such documents.
No, I have not looked for such documents.
Has your ministry conducted any investigations whatsoever into the allegations made by Belize of the importation of brown sugar into Trinidad in 2019 without the payment of CET?
The ministry is not responsible for the implementation of the CET, but we have sought to find out if there was any evidence of it, and what we have been advised that there is no such evidence of the claimant's claim.
What efforts were made to find out whether there was evidence in support of the claim? What did you do?
My ministry liaised with the agency responsible for administering the CET, so we liaised with the Customs and Excise Division.
Yes. So you asked them if there was any such evidence, and they said no. Is that the extent of the investigation?
Yes, that's correct.
Has your ministry considered the possibility that brown sugar may be imported into Trinidad and false declarations made declaring it to be refined white sugar?
My ministry considered it. However, we are assured that our agency is implementing the CET and that it would be very difficult for persons to make the claim that the claimant has done.
Has there been any attempt to reconcile the shipments of brown sugar identified by the claimant in its documents against shipment of refined white sugar in Trinidad?
No, there's been no attempts to do that. One of the things we noticed, of course, is that there are two different tariff headings. And what we have noted from the claimant's documents is that while they provide a list of brown sugar imports, there's no way to link that to whether shipments have, when received, have been charged a CET. So the documents provided by the claimant could not establish a link to prove its case.
Yes, but apart from proving its case, I'm asking whether or not Trinidad has sought to discover for itself whether or not these kinds of importations are taking place.
That's a good question, but as a representative of the Ministry of Trade and Industry, we don't have the power to do such investigations.
Your ministry just set up an anti-illicit trade task force, didn't it?
Yes, it did.
And that was in May?
Around that time, yes.
So what's the purpose of that task force?
The purpose of the task force is to reduce the incidence of illicit trade in Trinidad and Tobago, and it's to do it through a collaborative approach by bringing together all the relevant border agencies who of course have specific functions so that we could coordinate better in the fight against illicit trade.
Your ministry is of the view that Trinidad is currently experiencing a scourge of illicit trade. And I use that word because that was your press report.
Yes, that's our view.
Yes. Does not that scourge of illicit trade undermine the value of the data in the customs system, the customs records? Doesn't it undermine the veracity of it?
The data in the customs records would apply to things that were declared through normal channels. So incidences of illicit trade where they're reported to us usually come from the private sector, and they would report seeing stuff on the shelf. Sometimes we will not be able to see illicit trade through the data provided by customs, because those would be submitted by legitimate importers going through the normal process to declare their goods and pay their taxes.
And if there were false declarations regarding the importation of brown sugar, would you expect that to show within the data recovered from the customs system?
I would not have all the information, but the Customs and Excise Division would be responsible for dealing with false declarations.
Has the ministry done anything at all, apart from filing the witness statement, to address the allegation by Belize that there has been the importation of brown sugar without the application of the CET?
The ministry has reviewed the claimant's information. We have consulted with Customs and Excise Division, as I mentioned before. And yes, that's what we have done.
And at paragraph 17 of your witness statement, you explain that plantation white sugar is raw brown sugar bleached with sulfur dioxide, whilst refined white sugar is produced from refining raw brown sugar through the processes of purification, removal of molasses and non-sugar component impurities, and then recrystallization into refined white sugar. Is it your position that Belize is producing plantation white sugar through the use of sulfur dioxide?
My statement indicated one of the ways in which plantation white sugar can be made, and my statement also indicated the difference between plantation white sugar and refined white sugar. One is produced through use of sulfur dioxide. I know there are other ways of making it, and refined white sugar is produced through the distillation process. As to the exact details of how Belize produces its plantation white sugar, I don't have all the full details.
And you've also, in your witness statement, indicated that Belize does not produce refined white sugar. Is that your understanding?
Yes, that's my understanding. I understand that there is no sugar refinery in the CARICOM region that is making commercial supply at this time.
Yes. I have no further questions, Your Honor.
Yes, thank you. Does any member of the bench have any questions of this witness?
I have one question, Madam. Is it that the information that you got from Belize was not specific enough to check whether that was true or not. I mean, the list gives, I think, quantities of sugar that were imported, but it didn't give a name of a vessel and stuff like that. Is it that that posed a problem in checking the veracity?
That's one of the problems. And yes, you're right. There was no source to their documents. We could only surmise where the information was from, but also it only showed shipments. It did not show what was actually imported into Trinidad. So the information seems to have come from the exporter side. Mm-hmm. But moreover, there is a difference in tariff heading between raw brown sugar and refined white sugar. And it would be very difficult for someone to key in, because it's a computerized process, to key in a different tariff code and expect to get a different treatment. So the information was also highly implausible.
Okay, if you would have gotten more specific information, or if you will get more specific information, I suppose your ministry would be willing to have that investigated.
My ministry would ask the Customs and Excise Division to have that investigated, because Customs and Excise Division is responsible for fraudulent declarations, if such exists.
Okay, thank you very much.
You're welcome.
I would like to ask a question relating to paragraph 23 of your witness statement, please, Ms. Lewis.
Yes.
I think there you say that there are no restrictions on the price that companies in member states can purchase sugar, or from whom they should purchase the sugar, basically. You want to explain a little bit more what you meant by that statement?
Yes. The region provides protection through the imposition of a common external tariff, but the region has not taken the step of determining prices that member states can purchase their products from. Nor does the region make a guarantee that if a member produces something, another member would buy it. So what the integration arrangement seeks to do is to provide protection through the CET, but it does not go to details of prices.
Understood. So there's no legal requirement to purchase the sugar from any particular person. No legal requirement under the RTC. But when you say there are no restrictions, is there not a commercial restriction? That is to say that you wouldn't expect that an importer in Trinidad would purchase sugar from a source at a higher price than that importer would purchase the same sugar from a regional source. Do you see what I'm getting at?
I see you're speaking to the commercial considerations of the business.
Correct, yes.
Yes, and businesses would seek to do business as cheaply as possible.
Yes. Yeah. So is not a sort of a de facto restriction? It's not a restriction which is legally required under the RTC, but just as we know how commercial practice operates, would you expect that you, generally speaking, all other things considered, a commercial entity would try to source the sugar at the cheapest rate that it could?
Yes, a commercial entity would try to source the rate at the cheapest rate that it can, but with the imposition of the CET, the importation of products from extra-regional sources would be high, the price of it would be higher, and that would give some level of protection to regional producers.
Yes. Okay. Thank you.
You're welcome.
If I may, President, Ms. Lewis, good morning. You mentioned in paragraphs 32 to 34 of your witness statement the process under the safeguard mechanism. Could you put it in simple language so that we could all understand it? How this works when someone in Trinidad and Tobago an importer wishes to import refined white sugar. How does that work?
Well, first, I would have to point out that the safeguard mechanism works in the case of export. And you would need a safeguard certificate if you wish to export a product to another member state when some of your materials did not meet the rules of origin. So in the cases that we are discussing, the manufacturer would have used refined white sugar from an extra-regional source, and that normally would not comply with community origin. But with the safeguard certificate, the exported product would be treated as community origin and would be able to qualify for duty-free treatment in the importing member state. I'm sorry if it's not easy to explain.
No, that's all right. And I'm very happy that you mentioned that. So the refined white sugar comes from an extra regional source. But because of the safeguard mechanism, it is treated for export, let us say from Trinidad and Tobago to Jamaica, as being of local origin. Is that right?
It would be treated.
Okay. And when that
yes, that's correct.
When that white sugar comes into Trinidad, what is done? What is the CET on that? Tariff on that?
The CET on refined white sugar is currently 0%.
Okay. So you mentioned to my colleague, my brother Justice Witch, a short while ago, that something was highly implausible, and I was trying to follow exactly what you were saying, but then the discussion went in a different direction. Could you go back over that, please?
Yes. The claimants are claiming that persons who have a safeguard mechanism are using the safeguard mechanism to somehow import brown sugar. But the safeguard certificate is very specific to refined white sugar. And the refined white sugar and raw sugar or brown sugar have two different tariff codes. So if they are completing their import declaration, it's two different tariff codes. And so it's hard to imagine that someone could input a tariff code for refined white sugar and actually have a product on the port that is brown sugar.
So it's implausible. That's what you meant by implausible. Not that it couldn't happen or that someone couldn't make a false declaration. That's not what you were saying.
Correct.
Okay, thank you. This one other question. Is it possible for you to tell us, in terms of metric tons, how much by way of metric tons of sugar is imported into Trinidad and Tobago annually? Do you have those sorts of figures to hand?
No, I'm sorry, I don't have those figures.
Okay, and what about brown sugar itself? Do you have any idea of how much brown sugar is imported?
I don't have those figures at hand right now. Thank you.
Okay. Thank you, Mr. President.
Yes.
Thank you, Ms. Lewis.
By the way, the list of products which can be imported and treated as of community origin, such as, for example, the refined white sugar, that list is decided by COTED. Is that so?
COTED does agree to the rules of origin, and I'm not sure there's a list that of products that could qualify. Basically, what the treaty provides is for conditions under which they would be treated as as community origin, and those would be in our product-specific rules of origin.
So if a member state was quarreling with the allowance of the importation of refined white sugar, that quarrel, for want of a better word, that would really be for the attention of a group like Quoted, I imagine. And that's, of course, very different from the question as whether there are false declarations. Putting that aside, the question as to whether a good ought to be allowed in and then treated as one of community origin, that decision, I imagine, is taken in the halls of the community, not in this court. Would you be able to respond to that at all or not?
Yes, I think your conclusion is correct. It would fall to the treaty and not to the CCJ. And to your earlier question, yes, if a member state had a quarrel with another member state about whether the CET was being implemented appropriately or charged appropriately, the matter could be raised before the Quoted.
Sorry, I'm not sure I made that last point. That was quite a different issue altogether. All I was saying is that if the question arose as to whether, for example, refined white sugar could be imported and treated as a good or raw material of community origin, that question is not one for the CCJ, I would have thought. I would have thought that question is one for, I think, Quoted, but the halls of the communities that I put it earlier. So that's all I was saying. I wasn't suggesting for a moment that the issue of whether the CET is being applied is not for this court. I do think it's for this court, actually. But yeah, thank you.
Yeah. President, again, if I may, Ms. Lewis, just on paragraphs 37 to 39 of your witness statement, where you mentioned national caners. Now, national caners is, as I understand it, of things like ketchup and jams and so on. Am I right about that? And is it to that extent that they would have imported refined white sugar to input
That's
into
correct.
their manufacturing industry?
Yes.
As you know it, the raw brown sugar, is that for packaging in smaller packets and put on the shelves for retail?
Yes, that's the usual use of it.
I do not know at all, and I don't know if you know, but I'll still ask the question, is it that national canners also pack it into small packages of raw brown sugar and put on the shelves in the supermarkets of Trinidad and Tobago?
I'm not aware that they do that.
And when you say that, you mean you don't think they do, or you just don't know?
I just don't know.
Thank you very much.
Ms. Lewis, I just wanted to follow up on the trend of thought that was being expressed by my sister, Justice Rajnauth-Lee. Does your ministry, is it part of the responsibility of your ministry to monitor and assess trends in imports and exports?
Yes, it is.
Okay, so could you say whether there was any discernible fall off, any discernible drop in the quantities of raw brown sugar being imported into Trinidad from CARICOM states between 2018 and 2020?
We were able to look at that when the case came up, and yes, there was a decline in the quantities of brown sugar imported.
Was any effort made to assess the reason for this?
Not at this time, no.
Has that trend been since corrected? Or, well, corrected is a value-laden word. Has that trend differed in 2021?
I have not checked the data for 2021, so I can't speak to that.
But if there was a fall off in the period precisely in respect of which the claimant is making this complaint, that is not a coincidence. Or put it this way, it would be an uncanny coincidence. It would be something that would call for some investigation.
For a trade professional, it's not something that would be strange. While government doesn't engage in trade, we understand that quantities imported vary year on year for many reasons. Customers may overstock one year, so they don't need to purchase as much in the following year. So we know that there are various reasons for variations in quantity imported. Some of those reasons are economic. They could be due to foreign exchange. They could be due to the nature of the business. So
or climatic.
It's not concerning to us unless the trend is prolonged. And so in trade circles, when we look at trends, we usually watch a 3-year average to see if things even themselves out. Or if it's longer than that, but then we know we have a definite trend.
Okay. I want to follow up now on something that my brother Justice Witt asked. For the period in question, meaning 2018 to 2020, period that covers this complaint, the claimants did not provide the state of Trinidad and Tobago with important details such as the name. First of all, they have alleged that raw sugar was imported into Trinidad and Tobago. They have alleged that no duty, no CT was paid on that. They have alleged that that sugar may have come in under the guise, from my words, of being refined white sugar. Is that your understanding of their complaint?
Yes, that's what I understand the claimant has said.
Right. But they have not provided the name of the vessels on which they claim that this brown sugar came in. They have not provided the date on which the product was offloaded. They have not provided the port where the vessel discharged its cargo. If those details are provided, is it possible to establish whether those complaints were well made?
Those information, while they would be helpful, they're not sufficient. And the Customs and Excise Division will be the only one that would be able to indicate whether shipments came in without the application of the CT. So just to be clearer, knowing the port, the name of the ship, that isn't the issue. The issue is whether the imports will charge duty. And the information provided does not tell us that.
During the relevant period, did you discern a spike in the importation of refined white sugar? Or did you not, or is it that you never checked for it? Or is it that that would not assist one way or the other?
I did not check.
But if you had checked, and this is just a conjecture, I don't know why there's a feedback from that. If you had checked and there was a spec that coincided with a drop of the importation of brown sugar, then that would lend some substance to the complaint, would it not?
May not. We would have to do further investigations, and we would have to get the assistance of the Customs and Excise Division.
This is a kind of a rhetorical question. The CET is for the benefit of CARICOM states. And the state of Trinidad in particular, your state, benefits substantially from the CET because it has, relative to the other countries, a healthy manufacturing industry sector. So it is in everybody's interest that every effort is made by every state to diligently, vigorously police the proper implementation of the CSME. This is the first case, actually, where a state has brought a claim against another state. In all of our 15 years, 16 years, that has never happened. And so it is a little troubling that when matters have reached a stage where a state feels compelled to bring another state before the court, a lot of the answers in your witness statement were bland. I am not aware of this. I am not aware of this. And I know you were asked, well, you know, what steps did you take to see whether you can make yourself aware? Because as I said, everybody has an interest in ensuring that this mechanism functions properly. Are you satisfied that the ministry has taken all the steps that it can take to investigate this very serious allegation?
Yes, I am sure that the ministry has done what it can in consulting with the Customs and Excise Division on whether duties were applied on the imports of sugar during the period.
Okay.
Because, as I said in my statement, the Ministry of Trade and Industry is not responsible for the application of the duties. But once we heard about the case, we consulted with the Customs and Excise Division and sought their views on whether the duties were applied. And they've indicated that they were. So that's why I'm satisfied that we have done what we can.
Okay, thank you, Ms. Lewis. Yes, you may wish to state the head the addresses, or you may get back to your very busy job. Thank you very much. Well, sorry, is there any re-examination, Mr. Very sorry, Mr. Bharath? You're on mute, Mr. Bharath.
Sorry, no, sir, no re-examination.
Yes. Okay, well, thank you, Ms. Lois. We will take a 20-minute break here. It's 11:05. We'll come back at about 11:20 at 11:25. and we will resume at that point.
Right.
Okay, I think we're all back. Mr. Marshalleck, are you ready to address us?
Samantha, Your Honor, the sound was very faint. I'm not sure why.
Are you not hearing me properly?
Oh, I wasn't. I am now. That yes, you're very clear now. Yes, yes, we're ready. Yeah. Your Honor, the claimant relies on its written submissions in support and in reply to the claim. And we don't propose to repeat them, but to highlight our position and give our roadmap for where we see the claim is and where it ought to go. This claim invokes the original jurisdiction of the court and concerns not only an interpretation of a revised Treaty of Chaguaramas to ascertain the nature and scope of the duty of contracting states to charge and collect the Common External Tariff on the importation of brown sugar, but also the burden and standard of proof that must be met by a contracting state to prove breach of the treaty obligation, as well as the nature and extent of the relief, if any, which may be granted by the court if satisfied of a breach. It is clear that the burden of proof rests upon Belize and that the claim must be proven to the satisfaction of the court. The court has recognized that breach of treaty obligations can be proven by way of circumstantial evidence. It has held that such evidence is admissible and may be relied upon where two conditions are satisfied. One, the direct evidence is under the exclusive control of the opposing party. And two, the indirect evidence does not contradict any available direct evidence or accepted facts. The claimant has relied on documentary evidence to prove the breach of Articles 82 and 83 of the Revised Treaty of Chaguaramas. It is conceded that documentary evidence before the court is not of itself of sufficient probative value to make out the case. We accept that the quality of evidence presented by the documentation before cannot on its own make out the case. Belize sought but failed to secure disclosure of documents in the possession of Trinidad and Tobago, which would have constituted direct evidence of the importations alleged to have been made in breach of the treaty obligations. Belize says that the application itself demonstrates that any direct evidence of the importations is indeed under the exclusive control of the first defendant in this case. Belize further says that the inference it asks the court to draw from the circumstantial evidence presented does not contradict any available direct evidence or accepted facts.
Mr. Marshall,
Yes,
if you could just go back, please, to the important point that you just made. You said that you would ask for discovery, and the discovery would have shown certain things.
Yes.
There is Annex C, and there has been a lot of cross-examination on Annex C. There is an unredacted document, which you're aware that we have. Could you just so that I could understand how discovery of a document which says what sugar, brown sugar, came into the country and what was paid, or 40% duty paid on it, how would that have assisted you having regard to the cross-examination in on Annex C?
The disclosure sought was in relation to the shipments identified in Annex C. The disclosure had is in relation to the shipments disclosed by their, I forget the initials, the customs system.
But then, to be fair, Mr. Marshalleck, perhaps you should take us to Annex C, because I don't see a shipment, but you may have seen it. But there are no specific shipments in Annex C, and that is what I really would like you to be able to say. Having regard to what you claim as the failure to disclose or the refusal to disclose, how are you assisted in your case? Having regard to Annex C.
Yes. On the application for disclosure, and it's not an application on whichever part, a number of what we call bills of ladings were produced in support of, and that overlaps with the information provided in Annex C that provided the ports and the vessels and the dates and the times for shipments subsumed within that information. The disclosure provided did not address any of that, none at all. But it is not only that the summary in Annex C, the information contained in the summary in Annex C was provided, it is that there were further details, indeed naming vessels, ports, times, place, that were also provided in the documents that we refer to as bills of ladings that they have challenged as representing true bills of ladings. What they are, in fact, a compilation of information from bills of lading, and they're not the bills of lading themselves. They're retrieved. I don't want to give evidence, but there was material there on the basis of which, if one were interested in pursuing it, material could have been discovered. But the response to the request, as demonstrated by the evidence, was merely to punch in the tariff code for brown sugar and have the system print out all the shipments that were declared under that tariff code. And I must make the point that though that information, that system generated information, that system generated report would necessarily have to show that the CET was charged. That's because the charging and computation of the CET is automated. So once you punch the code, the software calculates the duty. And once the CET is programmed in as applicable to the applicable tariff code, the system will generate that charge for CET. So there can be no doubt that if you generated a report from the system, that it would have produced a report that said all the CET was charged and collected. The system could do nothing else. If you were truly interested in discovering material to substantiate, provide direct evidence of the shipments described, you had to go outside of that system. Trinidad made no effort to do any of that. It simply printed it, stood on it, says we've paid and collected on everything. That's the point I would like to make in relation to that. But
when you say
what I was conceding...
Just a minute, Mr. Marshalleck. When you say they would have had to go outside of the system, what exactly they could and should have done?
Well, there are two things. When a declaration is made, it, as Mr. Huggins explained, the system designates a lane to it. If it gets a green lane designation, it goes through without no inspections. And then there's a red which stops it and mandates a physical inspection of everything. And there's a range in between. There's no indication that there was any checks done in relation to any of those declarations to verify that anything in them were in fact true. But apart from that, the simple check that could have been made is that the shipments could have been identified and cross-referenced against shipments for refined white sugar and to see if there were any correlations. That hasn't been done. But why would Trinidad do that? Because all it can produce is a correlation that can't help them.
But I'm still a little stuck, Mr. Marshalleck, because let us assume that a shipment of what was alleged to be refined white sugar, which is 0 rated, came in and mixed in that system, in that shipment, that container, whatever, were quantities of raw brown sugar.
Yes.
It goes in the green lane because whatever reason, is 0 rated or whatever.
Not inspected.
Is not inspected. That's in January of 2019. When you complain in September of 2020, what can be done to verify or to assess whether that particular shipment was there was a false declaration made in relation to it.
You would have to follow it through, see where it is, and talk to the people involved at that point in time, because the shipment, the actual sugar probably wouldn't be around anymore. But whatever can be done, I think they're on the duty to do it. And this is an argument that we wish to make, that the obligation to charge the CET subsumes more than our obligation to program the charge within the computer system and to impose it as a matter of law, but it goes beyond to actually charge and enforce collection of it. And while it is clear that it was programmed into the system and it was being charged or supposed to be charged, where things fall short, in our view, is in the enforcement of it and demonstrating that proper steps were indeed taken to collect it, and when the allegations were made, to address the allegations. What, just to put matters back on track, because where I was really conceding that on the documentary evidence alone, the case is not made out. Where we're going with this is that the strength of the evidence in support of Belize's position really is circumstantial, and what the court is being asked to do is to draw inferences from those circumstances. And that taken in light of what can be said to be the probative value of the documentation, which is just a mere indication that a significant amount of brown sugar may have been imported from Guatemala and Honduras during the period. Just an indication. But when that indication is taken with evidence as to how the market in fact behaved during 2019, then a very powerful inference can be drawn. Because at the end of the day, after all the analysis is done, whether or not there was extra-regional brown sugar imported into Trinidad without paying CET, in fact, will be demonstrated more so by how the market responded to those interventions, rather than the official documentation provided, evidencing what was supposed to have happened. What we say is that while the evidence, the documentary evidence by itself might be insufficient to prove a claim, that when the indication given by that evidence is coupled with the way the market for brown sugar in Trinidad and Tobago in fact behaved in 2019, that a powerful inference can indeed be drawn, that powerful inferences can indeed be drawn that one, significant amounts of extra-regional brown sugar were imported into Trinidad and Tobago, which do not appear within Trinidad's records, and two, that the required CAT was never charged on those importations.
Mr. Marshalleck, you now have the total metric tons of brown sugar that the customs declarations indicate were imported into Trinidad from Guatemala and Honduras. And you also have the price, the value. We have Mr. Martinez's evidence that, if it is to be believed, and seems logical, no one will sell sugar below the number 11 price, whatever.
Yes.
Did you make any calculation to assess whether the prices on the declarations were at or above the number 11 prices?
I did, but the calculations were based on information provided confidentially in a number of returns, and I'm not sure that I can rely upon them or say anything about them. There were some information in discussion shared, and some calculations were done.
No.
My lord, I don't want to rely on that. Let me
Okay, go ahead.
I don't want to rely on that. This is what we say in response to that. The numbers that were disclosed were, from our perspective, shockingly low. And it just supports the notion that the official system is not catching the bulk of the importation. I will say no more than that, but this is where I want to go with this in terms of the inferences.
Mr. Marshalleck, excuse me. I am trying to follow you because I did not get the impression yesterday that Mr. Martinez was as guarded as you are being. I thought he gave numbers to Justice Witt. He thought that his price would be around X. And if you put in the refining and the CIF, plus the 40% CT, we would get to 560, and that he was selling more along the line. So I'm not sure if we're speaking about the same thing, but if we are, I had thought that you would have come prepared to show us from your evidence how we arrived at these figures, because that seems to be an important limb of your argument.
Yes, it is. But what we're saying, and we're not quite at the same place. What I was saying, and I acknowledge what Yona says, what we were saying is that the calculations in relation to the specific shipments disclosed, actually the actual numbers, whether that was done as opposed to the estimations that Mr. Martinez spoke about. But even if you do it in the wrong, the way Mr. Martinez does, it leads to the same conclusion. But to give you a precise calculation for those specific shipments, that wasn't possible based on the information available. There had to be certain estimations. But this is where I want to go with it, because I want to start with the general proposition, which I believe to be unassailable, and which has the force of reason and logic to support it. And it is that prices in a competitive market is fixed by reference to demand and supply. Where demand exceeds supply, prices go up. The reason for this is that you have too many dollars chasing too few goods. And where supply exceeds demand, prices fall. And that is because you have too many goods and too few dollars to acquire them. In 2019, what you have is very clear and undisputed evidence that the price for brown sugar fell. That is a clear indication that there was an oversupply, that supply exceeded demand. But supply exceeded demand in circumstances where the supply from CARICOM producing countries also contracted. Now the contraction, that should have raised alarm bells. That's an anomaly. If there was a contraction in supply, prices should go up. Prices don't come down when supply contracts. It means, by necessary inference, that the supply was coming from somewhere else. I need to stress that, because for the business people, it's very plain and obvious. The lawyers, like myself, seem to have a little more difficulty with it, but that's gospel. Prices don't fall in an environment except in a market, except where there's an oversupply. And how could there have been an oversupply when supply contracted from all CARICOM territories during the period? How do you explain that?
I think, Mr. Marshalleck, and I hope I'm not taking away from what you are submitting, but yesterday my colleague asked a question, I believe of Mr. Martinez, to do with the comparative prices. So he had taken us through an exercise which established what the price would be based on number 11 world prices. And I think she asked him, well, what was the price that sugar was being sold at by BSI? And I think he gave some figure that he, I wasn't sure he was referring to anything in evidence, but he gave a number which was produced by virtue of his calculation. I just wanted to nail down this point because we can arrive at some ideas to what the price based on number 11 could be in, say, Trinidad. But how do we compare the price that the sugar was being sold at by BSI and thereby confirm that it would have been less than the number 11 induced price?
Well, what you have is his testimony that it is impossible for extra-regional brown sugar to be sold in Trinidad cheaper than BSI's brown sugar if CET is charged. He expressed it that highly. He declared it to be an impossibility.
I'm not sure you answered my question, Mr. Marshalleck.
Well, where I am with that, if I understand it correctly, is that there are no specific numbers given to you anywhere where you can make the comparison. Mr. Martinez gave examples, but there were examples in support of his overall conclusion and to demonstrate the general statement which I've just advanced, which is that it is impossible for extra-regional brown sugar to be sold in Trinidad cheaper than BSI's brown sugar if the CET is charged. If we accept that proposition...
On this point, you're resting your case on that general statement rather than empirical information about what the price was that BSI was willing to sell in 2019.
Yes, there are some information.
I'm not just trying to do that. I'm just trying to understand. Yeah, sorry.
To some extent, yes. To the extent that the general statement rests on Mr. Martinez's own analysis of empirical data, then it reflects that empirical data. But that the empirical data itself has not been put before the court for the court to itself make comparisons and calculations, I don't believe sufficient of it. It's there in bits and pieces, but enough of it is not there.
Thank you.
Yeah. If you accept the proposition, the general proposition I just advanced, which Mr. Martinez sought to explain, that it is impossible for extra-regional brown sugar to be sold in CSM cheaper than BSI's brown sugar if the CET is charged. And if you also accept his testimony that there were instances in 2019 where BSI could not sell sugar into Trinidad because its pricings were being rejected and were being uncompetitive, then there is unnecessary inference to be drawn. Brown sugar was coming in without the CET being charged. There is much force in such an inference. We say that the inference gives rise to a prima facie case, which Trinidad was obliged to meet.
Could we tarry here for a little bit longer, because I'm still on the issue of the value now of the sugar coming in, and you have quoted number 11, and by now I think we all are very familiar with the concept of number 11. Okay, and you're saying and you're admitting that there is no legal obligation. There might be a commercial necessity, but no legal obligation on a private sector entity in Trinidad to purchase at number 11. I'm just trying to understand, if we take number 11 out of the equation, what is the value on which the CET is to be charged? Because obviously it's an ad valorem tax, and therefore it has to be charged on the value of the good. So how is the good valued in those circumstances? Is it simply the price paid by the buyer and seller, in that transaction, or not?
It should be, but how it's valued and how it's calculated and charged and collected is based upon the figure declared in the customs declaration and the supporting documentation provided in support of that.
Sorry to interrupt, sir, but that's an important point, because it seems to me that the valuation of the good is key. And I do know that in other circumstances, like the WTO, for example, there is an agreement on valuation. So you can decide, for example, whether a certain price agreed between seller and buyer ought to be disregarded because, for example, they're not at arm's length, for example.
Yes.
Okay, so is there any kind of valuation agreement within CARICOM that, putting aside number 11, would govern, would discipline the transaction between the buyer and the seller. So we say that the CET is charged on that particular value?
No, not as far as I'm aware. The CET is charged based on the declarations. And the declarations must be supported by the appropriate documentation, which is normally an invoice from the supplier.
As I understand it, it's the CIF value that is looked at.
Yes.
So it's 40% of the CIF value. And when of course, when you take the Guatemala total in 2020, which was 2,239 metric tons, and you compare that with the value, the CIF value, that would mean that they would have bought for 378 US dollars per metric ton. And if you put on the CET, that you would get to 500, that is an average, of course, 529 US dollars per metric ton. And I think Mr. Rui Martinez said that their price would be between 480 and 500. So that would be below that. Is that?
Yes, it may not be relevant, or I'm sorry, sir. Yeah. It may not be crucial for this case, Mr. Martinez, but it may be something for CARICOM to consider.
Yes.
You know, yes. The process by which goods are valued, because that's an issue in some other circles, and it's been dealt with by treaty. Thank you.
Yes. What we're saying, just to get back to the thrust of it, is that when proper regard is had to the circumstantial evidence and whatever can be taken from the documentary, and we say even if you take it at its lowest, that is just an indication that there were significant importations of brown during the period. We say that Belize has made out a prima facie case that brown sugar was imported during the period without the application of CET. And that it was then incumbent upon Trinidad to meet and rebut that case. They have sought to do so merely by printing off all the importations of brown sugar disclosed within their system and standing on it, saying that's all there were and that all the CET was charged in relation thereto. The trouble is, fundamentally, and this is where we started with the questioning, is how can that information, that evidence, rebut the very strong inferences in the face of the very real possibility that there could have been false declarations on the importation of these sugars? That very easy way of sidestepping the system drives a significant, undermines significantly the probative value of the list provided by Trinidad on which they rely. And when you take into account that this information is being relied upon in the manner that it is, without any further investigation, without anything else to suggest that there were any checks whatsoever made in relation to the shipments or the allegation, other than merely to ask a question and to generate a report from a computer system. When regard is had to that, we think the position is that Trinidad has simply failed to come to proof to rebut the prima facie case raised by Belize. At the end of the day, if the case is about relying on the records produced by Trinidad or watching what in fact happened in the market and how the market behaved, we think how the market behaved carries more weight, particularly in an environment where Trinidad is experiencing or has experienced the kinds of illicit trade that it has. And I might add, so too has Belize. There's nothing unique in the Caribbean about that.
You seem to be basing the existence. I'm sorry. You seem to be basing the existence of the ground for the inference on a factual premise. That is to say, the commercial landscape. Do you have any support from the jurisprudence? I think I asked about this yesterday. That would tend to help you here.
No,
because we're really coming from the way the market behave, and then you're asking us to make a legal conclusion based on that, i.e. that Trinidad did not apply the CET. Is there anything in the jurisprudence that supports you in enabling us, making us more comfortable making that inference? Yes.
Yes. No, I took it on board and we did have a look. The only material that we've been able to find is the material that we already put before Your Honors, put before the court, which is that circumstantial evidence is permissible and inferences can be drawn in appropriate circumstances. And the two conditions are set out before, where the direct evidence is under the exclusive control of the opposing party. I don't think there's any doubt about that in this case. And two, the indirect evidence does not contradict any available direct evidence. And it's in regard to the latter that I think Your Honor's question really drives down to, which is that if you have direct evidence from Trinidad saying that there was importation and the taxes were paid, how are you to draw an inference in the face of that contradicts that position? Well, our simple answer to that is that there is no contradiction. The two things can easily be true. They're not necessarily contradict. In fact, it can be very much, we would accept that it is very much the case that the shipments identified by Trinidad and disclosed did in fact pay the CET. But those aren't the shipments that gave rise to the market distortions. Both things can be true. And it would be explained by reference to the fact that the system is being evaded. And that's not so hard to recognize in the environment in which we operate.
Yes, and I think one or two of the cases you cited did in fact erect the reference on the basis of factual circumstances. So I hear you. I understand what you're saying. Of course, the requirement is that the circumstantial evidence cannot be explained in any other reasonable way. There's no other reasonable explanation for it. But I gather you're saying that is the case. There's no reasonable explanation.
That's what we're saying. There's no reasonable explanation, no other reasonable explanation for prices for brown sugar going down in Trinidad when supply from regional suppliers are also contracting. There's no reasonable explanation for that. And this is what sounded the alarm bells with the Caribbean Sugar Association.
Mr. Marshalleck, your answer to our brother about reasonable explanation rests in the market evaluation, right?
Yes.
In summary, your answer to this question about whether there's any other reasonable explanation, what you say is, look pragmatically at market realities. And if you look at market realities, then something does not add up. Hence, there is no reasonable explanation. So you say circumstantial evidence, the direct evidence is under the control of Trinidad and Tobago. Secondly, the indirect evidence does not contradict any direct evidence. There are two possible interpretations. Both can be true. That is to say, you could have the documents produced by Trinidad, CET could have been charged, but that does not mean also that sugar came in without CET. And then finally, you say, well, given that scenario, and when you consider the factual realities, the hard commercial factual realities of brown sugar trading, including number 11, then no other reasonable explanation exists other than brown sugar entered Trinidad without CAT. Some brown sugar entered Trinidad and Tobago without CAT. Is that the summary of what you're saying or not?
I could not have put it better myself.
Well, I'm just trying to understand you, not advocate your case.
Yes, no,
at least I understand, so that is, I'm happy for that. Thank
it's
you.
a perfect understanding of what I've been trying to convey. That's exactly where we rest. And I would add one thing to it, and it comes from a question that the president asked. The uptick in sales since the bringing of the case. The proof of the pudding is always in the eating.
Or in the smoking gun. You know, you were not able to unearth a smoking gun. You said you spoke to people who made certain concessions. Wouldn't that have been a smoking gun?
It could be, yes, yes.
And Mr. Marshalleck, what suggestion do you make as to the amount of brown sugar that came into Trinidad and Tobago without the CT being paid?
Well, this is where we go to the relief. And I want to make clear that, of course, all the reliefs that were claimed in the originating claim, a number of them have fallen away. And I want to take your honors through them. I think all we're left with, really, are the declarations sought at A&D. And while I have no instructions to withdraw the claim for damages, I will make no submissions in support of them. I don't think they can be successfully advanced. So from a practical perspective, damages are off the table. We're looking at two declarations only. The declaration at A does not have any reference to amount, and the declaration of D does. But we would ask that the reference in the declaration claim to quote approximately 3,000 metric tons be struck, so that it doesn't matter at the end of the day how much was imported. I think that went more to the claim for damages to trying to assess and put a value to it, which is no longer necessary. And in relation to the first declaration, there's of course no longer any claim against the second defendant, so that the reference to the second defendant in there should also be struck. I don't know if that helps.
That's very helpful. Sorry, if Justice Rajnauth-Lee is not finished, I won't intervene. I'll wait for her to finish. She had asked the question.
Please proceed, Judge. Thank you.
Yeah, Mr. Marshalleck, the principle of de minimis in this jurisdiction, if it, so that you say you're only seeking the declarations, is it that, let me see how I frame this. If it is that on the evidence, I think there was some evidence about 3,000 less 400 and something tons, etc., etc. If it is on the evidence that the possible, use your language, the unrebutted presumption, because I think that's what you are, that's how you're putting it. The unrebutted presumption of importation into Trinidad and Tobago of brown sugar without CAT was in a quantity that was de minimis. Should this court even grant a declaration or declaration?
I would say no.
No.
But if it's in sufficient quantity to cause a distortion in the market, which is the very basis upon which the inference is being asked to be drawn. If it's of sufficient quantity to distort the market, then declaration should be given. And we think there's considerable value to be had from it.
And your answer to that lies in the diminution of export from Belize to Trinidad over this period.
Yes.
What is your evidence? What is your evidence of impact? Is that your evidence? That the evidence of impact, at least for Belize, was that this anomalous decline in export to and import into Trinidad of brown sugar for this period that you have critiqued?
Correct.
Okay, good.
Correct. And we see the value in the declaration in that we think that if it is established that not only must the CET be charged, and it wasn't, but that sufficient effort isn't being made. If the treaty obligation is interpreted to include not only the passing of a law by Trinidad to charge the CET, but the implementation of a mechanism to put it in place on the ground, then too, that has value.
Are we talking here
but
about,
Mr. Marshalleck,
sorry, are we talking here about some form of strict liability? I mean, if it can be deduced from the facts that there might have been imports of this sugar which were not, where the CET was not imposed, not because Trinidad, the state of Trinidad didn't want to do that, but simply because somebody played some game and succeeded in defrauding the authorities. In a case like that, would that still be a liability of the state in this context?
Yes, it turns upon whether or not the obligation to charge it also includes an obligation to enforce it, and whether sufficient steps were taken once it was discovered that there was a possibility that it was being evaded to correct it. Here on the latter score, we say nothing has been done. There hasn't even been a proper investigation of it. Trinidad seems to have been content to printing off the report from its system and just saying we've charged CET.
Mm-hmm.
And we would say that's not enough, doesn't go far enough. We had argued in the written submissions, I saw references to it, but in the reliefs, I didn't see any claim in relation to it, but it was also pleaded to in the defense, and that is a breach of Article 9, which requires that you take all steps, all reasonable steps, to put the treaty requirements in place and to operate it as it was intended. So
Okay.
there is that overarching obligation.
Mr. Marshalleck, I cannot but remark on the fact that you are presiding over a case which is rapidly dwindling before our eyes. It started out in quite some expanse, and it has come down now to what I gather you're asking for right now is a simple declaration. So I want to ask you about the declaration. I also want to ask you a question about another claim you have, abandoned damages. But in relation to declaration, first of all, if all that you are now asking for is a declaration that the defendant failed to impose the CET, would that objective not also be satisfied by appropriately worded statements by this court? Do we need to go to the extent of making a finding that there was in fact failure to observe the obligation on the CET, or if we were to word the obligations on member states in such strong language as would be appropriate, would that not satisfy you?
It could. It could.
So okay, so that's one. I gather you're not giving up you're holding on to the very last vestige of the case, that is to say the declaration. You're not giving that up, but you're saying that in the alternative, appropriately worded statements by the court would be appropriate.
At the end of the day, we want to see the market function as it was intended to. And if that can be achieved by that type of guidance being given in clear enough and strong enough terms, then that's fine.
Okay, thank you.
Mr. Marshalleck, it seems to me after all this that what we are coming down to is essentially a failure by customs to monitor or to examine goods which were being imported and declared to be of a certain nature, and it was simply a dodging and evading of the payment of duties. Is that the case?
Yes, except that it's systematic. It's not just one or two imported, one or two shipments in respect of which it happens. It happens continuously, and that has an impact, a large impact over time. In fact, I had referred to the International Index Against Illicit Trade, which is done by an international organization with the intention of trying to put a stop to all this illicit activity. And that's precisely because they undermine entirely the benefit of trade agreements such as CARICOM. So while it might seem to be a simple and, well, from Belize's perspective, might even, there's nothing extraordinary about customs evasion. When it approaches a systemic problem, it undermines the benefit of these trade arrangements entirely. And so I take the point that yes, it comes down to that, but I want to emphasize that that is a significant pillar on which all these arrangements rest. And it is central if they're to have the practical effect that they're intended.
You have answered me, thank you.
So I want to go on to the other question then about the damages remedy which you have abandoned, and that has saved us a lot of time because I wanted to ask you some questions about that. But could you just say in general terms though, your position on the stance taken by the defendant, because the defendant is saying that this is really a case which should have been brought by BSI using the Article 222 procedure, and that in enlisting the support of the government of Belize, we are witnessing an attempt to circumvent Article 222. Do you have any comment on that?
I think while it may have been open to BSI to go that route, it was also open to Belize to come this route. And Belize is demonstrating support for the sugar industry in Belize and insisting on strict compliance with treaty obligations by Trinidad. And I think that it is entitled to do so.
Because in a sense, the private individual, before that person can proceed, must in fact go to their government and seek the blessing, if you will, of the government, and the government can decide, well, no, we are going to take the case forward. So in a sense, and I'm just asking for your comment, it seems to me that the primary right, if you will, is in the government. And it's only when the government says we're not going to go forward, or doesn't indicate otherwise, that there's a secondary right which arises in the private individual. Is that how you see it as well?
That's how we see it.
I think it's a larger than that, though, Mr. Marshalleck, because one looks at the case which was brought against CARICOM, and one sees what has evolved out of that case, the happy settlement, and apparently the reciprocally beneficial settlement which has emerged in agreed order, etc. And it seems to me that there is simply no way that BSI could have achieved that in litigation against Trinidad. So I think that makes it all the greater the need for Belize to have acted.
I stand corrected. That is indeed so.
Just to follow up on something that was just raised, Mr. Marshalleck, you mentioned that this was, in the view of Belize, a systematic breach and not a one-off breach that occurred during the period in question between 2018 and 2020. Is there any evidence, or does Belize have any reason to think that this alleged breach is continuing?
Given the uptick in sales, I think there may have been some increased vigilance. So I don't know that it's continuing to the same extent.
If at all.
It's hard to say, if at all.
Yes, anything else?
Those are our submissions.
Yes. Sorry, go ahead. Oh, there's a feedback. I thought someone was saying something. Mr. Bharath, do you have two devices on in your office?
No, I don't.
You need to mute one if you do.
We don't. Anybody has a device on? All off.
Okay. How long do you propose to be, Mr. Bharath, do you think? Of course, we would interrupt you from time to time, but...
I'll try to be between 25 to 30 minutes, perhaps less. A lot has been conceded, so...
Okay, well, proceed.
Thank you. Perhaps...
It's a bit of an invidious undertaking that you engage with Mr. Bharath, because as you are very conscious, we are in the lunch hour, and therefore, if you go beyond that 25 to 30 minutes, then you get into the red zone.
Could I suggest that we all have lunch and come back here?
You want to come back? Okay.
Yeah, I think so, in a different mode of feeling.
Okay. Okay. So we take
Mr. Bharath, before we break, that is a wise choice, you know. There is research from the Israeli Parole Board, which suggests that that was a very wise choice. If you haven't seen the research, look it up.
I will, yes.
Good.
Mr. Bharath, there is the countervailing view, however, that anybody who addresses a tribunal after lunch is looking at sleep being made.
Yes.
It's the double-edged sword.
Yes.
All right, so let's take the adjournment until 1:15. So we'll be back promptly at 1:15. Well, that's actually Trinidad time.
Thank you.
Okay, I think we are all back. Mr. Bharath, are you ready?
I am. Shall I start, sir?
Yes, please proceed.
Thank you. I begin by perhaps repeating my learned friend's submission on the evidential effect of the documents which he has produced in his claim against Trinidad and Tobago. And I want to quote the words of Mr. Marshalleck in this form. He says, the claimant has relied on documentary evidence. It is conceded that it is not itself of probative value. We accept the quality of the evidence cannot stand on its own. Now, that is the evidence which they have brought in respect of this claim against Trinidad and Tobago, which has now dwindled to reliefs to be found at page 118A and D. May I just say at the onset that I don't know of any particular case, and I've been at this for 34 years now, but I don't know of any particular case where declaratory relief has been sought in which no specific declaration has been sought in respect of a specific item, and in which no subsequent claim has been made for actual redress, save and except, of course, if there's declaratory relief in respect of someone's status or under the Constitution or in respect of a particular act. But I don't know how far one can go with a bare bones declaratory relief that something has occurred when it is difficult to pinpoint what the occurrence is. But may I just also add that I listened with intent at the evidence of the witness, Andy Sutherland, who was, of course, the representative of the state of Belize in this matter, at the end of his cross-examination, when he said these words. I asked him, I am asking you one last time, are you accusing anybody of impropriety in respect of CET? And if so, where can I find it in your witness statement? Where can I find a flagrant breach of the customs laws of Trinidad and Tobago, indeed on anybody's part? His answer was quite clear. Counsel, I cannot admit to that. So you now have the position where the actual representative of Belize, by way of the witness Andy Sutherland, and also the counsel for Belize conceding that the case which he has brought and on which the documents have been used to support his case cannot amount to anything which can suffice to carry this case further. But what is interesting is my learned friend...
Sorry, Mr. Bharath, is that a fair characterization of what counsel said? I don't think so. What he said was that as far as the documentary evidence is concerned, you're correct that that is not sufficient to support his case. But I thought he then also said that that evidence was supplemented by the evidence of the market. And I thought he said that when combined together, that gave, in his view, rightly or wrongly, rise to an irresistible presumption, which your client is asked to respond to. Am I not right?
That is what I was going to deal with now. Thank you. You anticipated my thought process. So if I may, what counsel did indicate was...
Sorry, Mr. Bharath. My brother anticipated your thought process, but I think he also corrected your expression, yeah?
Yes, thank you.
Good.
But may I just say that the next step that actually the counsel for Belize went on to advance the proposition that even if his documents didn't meet the standard required, the probative value, the necessary level to provoke the conscience of the court, then he moved to the next step, which was the market forces. And I want to address the issue of the market forces in respect of this case, because a lot has been said about number 11 and the prices which are perhaps set out in respect of, I think it's RM, one of the exhibits of Mr. Martinez, of Number 11. I want to suggest, first of all, my lords and my lady, if you look at that document carefully, that document does not have an author, one, and secondly, it contains information other than the prices of number 11. It contains a standard figure of $60 for the conversion of the sugar to a particular state, and it contains a figure of $60 for freight. So notwithstanding what part of the world that sugar comes from, if you look at that particular document, they've been superimposed into that document two figures with respect to additions to create a value. And may I just say in saying that if you look at that document itself, which for one moment, Trinidad and Tobago takes the position that that document is not a genuine document, and I'll explain why. For one moment, if you take the figures on that document, it is a daily figure with respect to the value of sugar. Now, daily value. In Belize's witness statement, they referred to the one value of Belize's sugar at $540 US dollars per metric ton for the whole of 2019. And yet still, there was no evidence given as to the fluctuations in the value of the sugar or the cost, the selling price of sugar that Belize gave. But in respect of that number 11, may I just make three
Mr. Bharath, just before you go on, and I don't want to interrupt you too much, but I want you to address something for me on the evidence. What is this court to do with the viva voce evidence that you elicited in cross-examination? What is the approach this court should take to that evidence, and what is the probative value of that evidence? If in other words, if a cross-examiner asks a question and a witness gives an answer to a question asked, or evidence emerges out of a question asked, what is the probative value?
Yes, so I will address that.
We'll come to that, yeah.
Yeah, I will. So if I get back to number 11, I just want us to be careful about number 11, because the number 11 deals with futures contracts. So what that means is on a particular date, for example, May of this year, what would traders who would depend upon or play the market or hedge contracting on the basis of futures? It does not mean that was the historic value of the sugar on a particular day. There is a particular website that gives us the historic prices of sugar on any particular given day. And secondly, the number 11, and it's there on the internet, the number 11 prices that were set out there comes from a particular website. It's called the ICE website, ICE. And in that website, there's an official body that sets out what those prices are and explains how that mechanism is to work. What had happened?
Mr. Bharath, could you just pause a second? We are having a difficulty with Mr. Marshalleck and Ms. Matute-Tucker. It doesn't appear as though they are on at this time. So the registry is trying to contact them. So if you can just pause a second.
Mr. Bharath, while we await them, could you confirm with us when they come back in the correct document that you're referring to, exhibit?
Yes,
I think it's RM1, and so I'm a bit confused because I'm trying to find.
No, it's so the futures. If you look at page 937 of Rui Martinez witness statement, 937 of the record, or RM4.
RM4?
Yes, 937. Milady, if you look there while we wait on Mr.
No,
Marshall.
you can proceed. They're back with us now.
Okay. If you look at that document, Milady, I'm glad you raised it. You will see there's a $60 US on both sides of the column that's consistent throughout. So what has been done to the futures prices? Other prices have been added. Sorry. I hearing a feedback. So if I may, the number 11, nobody ever gave any evidence, and this is to address Justice Jamadar's question. The person who was given the evidence in this case is not the person with the direct knowledge of the actual operation of number 11, for example, if we will take that as given. The operation of number 11 comes from a website that gives information, and one would have thought, Justice Jamadar, in answer to you, that if you were to be taking information from a website, you would identify the website, you would identify the body that was responsible for the production of the figures, you would set the stage to explain what the figures are, you would set the stage to explain how the figures came about, how they were compiled, and then on that basis, you would annex the document. But whatever, for example, Mr. Martinez had said in answer to me, most, if not 99.99% of the time that Mr. Martinez answered me, it was on information that he received from others. So it wasn't direct evidence that he was given. And what was strange is that although Belize was a member of the board of the sugar board, nobody from the sugar board came and gave evidence. They sought to attach documents to their proceedings, which did not have a physical author that X produced this document or Y produced this document. So what I'm saying is, even when Mr. Martinez was asked questions by me and did volunteer a whole pile of information, the information he gave really didn't advance the case any further. His main point was, and perhaps I should address this frontally. His main point was, there's no way you will sell sugar under number 11. My first answer to that is, nobody said that number 11. No, you don't have the expert evidence to explain to you what number 11 is. Mr. Martinez is not qualified to say what number 11 is. And this court should not find that number 11 is the standard by which the world regulates sugar prices. He never said that sugar prices were regulated by number 11, or that X had to actually supply sugar at a particular cost price as suggested by number 11.
Mr. Bharath, just for my benefit, can you be clear, a little clearer perhaps, on what ground you are putting forward? Because I'm hearing two different grounds and they might be inconsistent. One is that you are doubting the validity of the information that we got. It was not adduced in the correct way, for one thing, I think you're suggesting. On the other hand, you seem also to be saying that there is no requirement in any event for the price of sugar to be regulated by international prices. Now, are you saying both of those things, or are you sort of targeting one or other of them?
Well, I'm saying, first of all, that the number 11 prices are not a regulation by which, it's not a gospel which must be followed. In other words, what Mr. Martinez was saying is, you can't sell under number 11. So I
think we understand that. However, he did give a fairly elaborate explanation as to why he thought that was the floor. Are you going to be dealing with that? Because quite aside from the issue as to whether he got it right or wrong, whether the number he puts forward right or wrong, what about the concept? The concept being that given all things being equal, it is commercially illiterate, I think somebody used that word, for a buyer to be purchasing sugar, for a seller to be selling sugar under the number 11 price. I'm very interested in your response to that, because I'm not sure you've actually dealt with that point. Thanks.
Well, that first of all assumes that number 11 that is produced to the court is a valid document, one, and two,
No, I'm not trying. Sorry, I'm not at the moment interested in that. I'm interested in more in the concept.
Yes.
That whether you agree or not, if the court were to accept the numbers that he gives us, would you not agree with him that it would be financially illiterate for a buyer to be selling below that price?
No, I could answer that. That depends upon demand. You could have whatever price you want at the end of the day as being the sugar that's being traded. But in terms of the demand for the actual item, it does not mean to say, for example, that if you have a surplus in Belize and Honduras that you are not using, that you may not decide to sell that at a lower value. It doesn't mean to say that a country does not have extra surplus on its hands. It does not mean to say, for example, that if you can produce sugar at a lower price than the general market is selling outside there, that somebody wouldn't buy from you. And the opposite makes sense too. Why would you at the end of the day?
Mr. Barrow, just pause, because I'm not sure you answered our brother. I believe, I mean, if I'm wrong, Justice Anderson, please correct me, but my understanding of the question is, on the assumption, forget whether we call it number 11 or whatever, on the assumption that there is a floor price for the international sale of sugar, would it not be, generally speaking, to use Justice Anderson's language, which I quite like, commercially illiterate, for a person who could get the number 11 price, because that is the whole point of a number 11 market, to trade under that value?
But who says, my lord, that you could get the number 11?
No. They're two different. You see, that's why I brought you back to it. Our brother is asking you he is accepting that you may be challenging the evidential value in relying on number. That's not what I think our brother is asking. Maybe I should not intervene and let him ask what he wants to ask. But I think he is creating a hypothetical for you on an assumption that number 11 is an international floor market price.
Sure.
Why would a person who has surplus sell below that?
And I think I answered that, my lord. I said, for example, it depends upon the circumstances of the country. If you have surplus, for example, that you want to get rid of quickly, there's economies of scale, for example. For example, a motor car, a fleet of cars might cost less.
Mr. Bharath, I really wonder whether you understand fully the concept involved in arriving at the number 11 prices.
Yeah.
Because my understanding is that the number 11 price takes into account those who have surplus and those who don't have surplus. Sugar is an internationally traded commodity. This number 11 price, as I understood it from Mr. Martinez, I'm not the expert, and this is the first time I'm dabbling in this area, but my clear understanding is that once you are a purchaser or a vendor of sugar, this number 11 price indicates the mean, not the mean, but the figure below which no one will trade sugar. So it doesn't matter whether you have a good crop or a bad crop.
If I may, President, I think that certainly my understanding is slightly different. One doesn't talk about a number 11 price. One talks about a number 11 contract. And basically, this has to do with the whole business of derivatives. The real value is the contract. The underlying asset is the commodity. I think as well that we should note that, take for instance the oil. Oil was at one point in time $38 or below. It is open to a buyer to buy futures, because that's what you're doing, buy futures, and you're in a sense gambling, hoping that the market goes up. In which case you then sell, you can sell the contract without selling the underlying asset. So
I raised the question with Mr. Martinez because I thought that his characterization of number 11, it's not a market. It has nothing to do with a market. It's a benchmark. It's a benchmark. There are two prices which are involved: the contract price and the world price. The world price is the price at which one would go into the world market and find it being sold there. But this doesn't constrain contractors. This doesn't constrain contractors. Contractors can buy below or above. The other thing the other point which I wanted to make is that I don't think it is right for us to think of number 11 in terms of price below which one would go. It's a benchmark. So it's nothing more than a benchmark, and it's a contract, and it has to do with contract futures. It has nothing to do with price as such, because the underlying way in which prices are determined will depend upon supply and demand. That's it. So I just thought that I would. This is just would share my understanding of it with the court.
And in fact, Mr. Justice Burgess, if I may add, if you go to the website, that's why we all falling down. We all thinking that this number 11 is the price of sugar, and that's wrong. If you go to the website, it deals with a contract, and it's a specific value of quantity under that contract, and it's 120,000. I can't remember if it's tons or pounds or whatever it is. It must cross a threshold. So the court is falling into the I guess falling for what Mr. Martinez says as regards how the number 11 works, and it is not that. It's a futures contract. That is why I was trying to explain to you, Mr. Justice Saunders, Mr. President, when we started off, that what you're buying in May is a futures price. In other words, you're hedging. You're saying if I buy in May for $10, I could sell in December for 20. So you're buying, in other words, what are these traders dealing amongst themselves? What would the futures sell for? It's not the actual price of sugar. And if this court finds that number 11 is the actual price of sugar, the economists around the world, it's just not going to tally. It's a futures market. It's buying and selling. And may I just say, and I'm very happy that Mr. Justice Burgess assisted. The selling price of sugar, buying and selling of sugar may depend, yes, on the economic forces, but at the end of the day, if a country has more to sell or stockpile and a price is being offered at a certain amount, why is it a sin for a country to sell at a lower level than the actual price that is being offered in the market?
So you're suggesting that a company that is organized to maximize profit would sell its inventory below what it can sell it for?
But we can't find that here, Mr. President. We cannot sit here and say what the market. We don't have the evidence. We don't have experts addressing us on the market forces here. But what we actually doing here is we actually putting ourselves in a position where we are second guessing. And may I just say this?
One of the problems we have, Mr. Bharath, through the president, is that I seem to recall my brother Justice Jamadar asking for an explanation of what this number 11 was. And I seem to recall a very, very elaborate explanation of what it was coming from the mouth of a witness of fact, that is to say, Mr. Martinez. Correct me if I'm wrong, but I also seem to recall that the court gave you an opportunity to question Mr. Martinez on the description that he had given. Now, I don't know whether we're going to revert to a situation where you are going to be giving evidence from the bar table, but maybe you could advise us, how do we proceed in these circumstances? Because you had every opportunity to have indicated in the course of the evidence being given by the witness of fact that what he was talking did not tally with your understanding of number 11.
But I think, Mr. President, I think I raised a question with him in that regard. And I think that he agreed with my characterization of sugar number 11 as a futures contract. I think that he agreed with that. But the other thing, Mr. President, while I'm here, which I think we need to note, is that we do not know the date of the contracts which govern the delivery of the sugar in question. And it may very well be that those contracts were bought sometime, years before, or at a different time, because this is how commodities futures trade. So I just wanted to make that point, because I think that perhaps Mr. Bharath could address it as well, because I did raise the question.
Yeah, may I say, President, that yes, I do recall my brother Burgess raising the question. I must say that my recollection of the concessions made by Mr. Martinez to what my brother raised may not tally quite with the recollection my brother seems to have. But I do think we are at a very important point, because there are some of the things that we're discussing which I think could probably be reserved for deliberations. But in terms of what the evidence is from the witnesses, I'm a little bit perplexed as to how we move forward, because if counsel was given the opportunity to cross-examine on the description that the witness gave as to what the number 11 was, and if I recall correctly, we can consult the record, counsel declined the invitation. How is it now that we are going to entertain evidence from counsel at the bar table? Perhaps you can assist me, or somebody else can.
I can. So first of all, my position has always been from day one that document called number 11 is not a genuine document issued by a maker that can be checked. So where do we get the figures from to arrive in the first place at number 11 figures? Because the figures in number 11 runs about over 100 figures, and they're different dates to the figures. How are you going to marry the dates of the figures with the dates of the particular that Belize speaks about? So if, for example, we spoke in 2019 of January 14, 2019, what was the price of sugar on the number 11 as opposed to what Belize was offering? Where's that evidence? That evidence is non-existent. What was the amount that Belize was offering the sugar at on the 12th of February 2019 compared with the number 11? Doesn't exist. So at the end of the day, I didn't cross-examine him, because as far as I was concerned, the evidence was not there. The evidence which married the actual price that Belize was offering and the actual price that was on the number 11. And may I just add as well, Mr. Marshalleck said this morning that the price in respect of sugar changed and went down in 2019. Where is that evidence? Where is that evidence? You have one, if I may, you have different players in the market with respect to sugar, and I'm asking this court to just give me a chance. You have Barbados, you have Jamaica, you have Guyana, and you have Belize. And you have all the other players outside, China, India, name it, that sells sugar. And that's a matter that the court could take judicial notice of. Just because Belize doesn't get the price that it wants in respect of sugar, which it doesn't produce to the court in terms of it's saying that I'm selling at a particular price and nobody's buying from me, that does not logically mean that some wrongdoing is happening on the other end. You have to have the inputs from everybody as regards what price everybody's selling at in a market economy to determine why are they not buying from Belize. And the other point is, what about things like, which we have not considered as a court? What about things like credit terms? What about things like the payment in foreign currency, whether they pay in pounds, one allows to pay in pounds, one allows to pay in euro? What about the issues involving the difficulty to get foreign exchange? All of these issues we never took account of. And what we are saying is, because Belize didn't get the price that they were offering their sugar at, which we don't even have, as far as we are concerned, some ratch took place in Trinidad and Tobago where CET wasn't paid. And may I just say one other thing? All the importations in 2019 of Belize sugar exports to Trinidad, where is that evidence as to what price it was exported at to Trinidad and Tobago? There is not one scintilla of evidence that Belize has produced before this court to show what price the sugar came in at different dates, and to take the court to it and say, listen, I sold this sugar on the 18th of April 2019 at X, and this was my price. Not any evidence of that whatsoever. So how do we compare what with what? How?
So Bharath, could I ask a question just to have clarification on one thing you just said? You said that there was no evidence that the price of sugar went down in 2019. Are you speaking specifically of Trinidad and Tobago? Or are you talking about the world or the region? I wasn't sure, and I wanted to get that clear, because I know Mr. Marshalleck, one of his pillars of this case is that the price of sugar but could not have been maintained if the CET of 40% was being paid. Are you suggesting that there is absolutely no evidence before this court as to that price falling?
Lady, if you were to go, following from Justice Anderson's point, if you were to take number 11 as being gospel, which I say we can't because we have no expert evidence on that, that price varies day to day. And I showed you just now there are almost 100 and something entries over a period. When you talk about a falling price, that price may fall and go up and down daily, hourly. We have no evidence whatsoever as to what that price was. The only evidence we have of a price, my lady, is the evidence in the witness statement of Rui Martinez, where he talks about 540 US. But if you were under if they were supplying sugar to Trinidad and they said they supplied 475 tons to Trinidad and Tobago in the whole of 2019, where are all those invoices? Where are all the prices to show the court what price they were offering the sugar, what price they were getting in Trinidad and Tobago? I'm saying we can't move from that with the lack of evidence to say, because Bailey says they weren't selling, therefore some ratch took place in Trinidad and Tobago, some criminal offense.
Mr. Bharath, I find that interesting because I do recall yesterday I asked Mr. Martinez about his selling price. I don't know if you recall that question. And if there was any document, any evidence in the matter as to what Belize's BSI selling price was. And I believe, I may be wrong, because I haven't gone back to check that note, but I believe he sent me to chart 2 of a document that was on the screen. He spoke about the fact that he wouldn't sell below number 11. I mean, the note can be checked, but I found that explanation interesting. I don't know if you have a note of it, and if you can correct me if I'm wrong, please.
Milady, I don't. Milady, I'm hazy on that. I cannot remember that line of questioning. What I do remember Milady asking him, for example, was what is the input cost to create the sugarcane? And he said, I don't know, ask my finance director. Then when I asked him, how do you arrive at 2,000 X amount of US dollars lost? He said, I don't know, ask my finance director. So how can we move from that position, ask my finance director, on those two issues of commerce and money, to where he explains how he arrives at a figure, and a figure cannot, and may I just say this again, and I'm sorry to be so forceful, a figure for sugar cannot be one figure for the entire year. That is impossible. If this court were to find that the price of sugar is one price for the entire year, I don't know what the economists are going to say.
I suppose they're going to say that we are wrong.
Well, I don't want to say that, but I'm cautioning the court, and may I just say so respectfully that when we start getting into issues of economies, futures, number 11, and all these things without expert advice before us, it means that we're falling into a state of uncertainty where none of us are experts in this area. And that coupled with the fact that the evidence which we received, if I may say so, Mr. Martinez indicated more than once, somebody told me this, somebody gave me this. And is this court to make findings on the cost of sugar, the price of sugar, on the basis that somebody told me this, somebody gave me this?
I don't know whether he was admitted formally as an expert, but the impression I got from his recitation of his qualifications and experience, Mr. Bharath, I'm sure you remember that you had asked him a fairly simple question about his background, and he gave a much more extensive answer than I think you might have been expecting. That suggests to me that Mr. Martinez certainly considers himself an expert. Wouldn't you agree?
Well, an expert in what, Malak? You see, why I'm saying an expert in what? If you are an expert, for example, in a particular field with respect to sugar, and you want to produce evidence that sugar was being dumped on a particular market, for example, won't you produce the evidence that the sugar was being dumped and identify the source and grounds for why you make that conclusion? If you're referring to number 11 sugar prices, won't you print it out of the internet and explain how it came about, what is number 11, how futures operate, how the price operates, why it fluctuates from day to day? Why would you just take a document and simply annex it to your witness statement by saying, there's one paragraph, Mr. Justice Anderson, where he says, somebody hand me a document, somebody gave me some information and I annexed it here. And this is a case where, and if I may say so,
Mr. Bharath, I think it's a little more complicated than that. I think that merchants or business people have another concept of evidence than lawyers have. He is clearly a man who is doing this kind of business for many, many years, like the other gentleman who we heard, the director. These people don't think in legal terms as we might want to do, but they know what at least they seem to know what they are talking about. They know their business. They have been in that business for years. So I simply think that their idea of what evidence is might be very different from what lawyers accept as evidence.
Well, may I take the argument on another level? May I suggest something to this court? We have the CET value. Now, we're talking about redacted now. We have the CET value. We have the quantity and the total quantity. So from the CET value, which we know is 40%, we could work out what 100% is, and we have the actual weights. Suppose, for example, that we were to do a simple calculation and see what the prices are that the Belizean, that Honduran and Guatemalan sugar came in on average. And suppose it was less than what Belize was indicated the price was for the whole of 2019, which makes no sense to me. Suppose that is the case. Are we going to conclude as a court that by reason of the fact that the sugar was sold at less even after CET, than Belize was offering the sugar, that somebody, that's impossible, that those things didn't occur?
Well, that's why it was relevant to have those totals, at least those totals of weight.
Is this court going to
we can make that calculation?
And if you do, you will find quite pleasantly that the figures amount to less than Belize was selling, were allegedly selling sugar with no evidence of what the sales price was. So I'm asking the court candidly, and this is my question respectfully. Suppose that price turned out to be less with CET. Is somebody saying that some ratch took place, some illegality took place? Is somebody saying that Honduras was crazy to sell the sugar this price? So what if they were crazy to sell the sugar this price? So what if somebody bought from Honduras a little more expensive because they could get 9 months to pay instead of 2? So what if Belize had a drought in 2019, which they kept in their back pocket? I had to ask that question. Belize never once said they had a drought in 2019. I had to read that letter and their crop dropped by almost half. And they had several problems in Belize in 2019. How does that affect Belize's ability to supply in 2019? And how does that impact upon the commercial world in Trinidad and Tobago when somebody needs to buy something with a given time with certainty? How do all those factors fit into the equation? Can we see as a court that all those things are not taken into account and we just look simply at the fact that Belize was selling at this price, somebody was selling at more, less, so therefore some rush took place? We cannot reach that stage by just looking at things like this and saying if you come under number 11 and you sell, you have to be commercially crazy, you're committing suicide. That can't follow logically. It cannot. And may I also say this? When you look at the case law, and I'm very, I guess, I would say educated by Mr. Justice Anderson. I know he has quite a bit of experience in this area, but he did ask a pertinent question. Justice Anderson asked the question, well, if you have people saying on one end, it must be so, it may be so, it have to be so, but people on the other end saying, listen, this is the evidence, the hard evidence that I have that this actually occurred, it was paid. How do you marry? My junior overnight, I must confess, I have not read this case. My lords, I spent all of last night. I got 2 hours sleep preparing for today, but my junior found this case very early this morning. And Mr. Justice Anderson, again, I must thank you. It's a case concerning a temple of prayer. We hear probably something arising from a Middle Eastern country, India. It says, in the face of the facts stated, all of which are established beyond controversy, it is an unproductive exercise to have recourse to presumptions or inferences from the subsequent conduct of parties in an effort to establish that the mixed commission must in fact have made a decision delimiting the Dan Greek by agreeing to the frontier line shown in or in the form of Annex 1 or in the form of any sketch map. No presumption can be made and no inference can be drawn, which is inconsistent with facts incontrovertibly established by evidence. So Mr. Justice Anderson had asked us yesterday, how do you marry on the one hand that with solid facts? And it says no presumption can be made and no inference can be drawn, which is inconsistent with facts incontrovertibly established by the evidence. And the question is, do we have facts uncontrovertibly or incontrovertibly established by the evidence? Mr. Marshalleck conceded a short while ago that the duties were paid on the imports that came in through customs, the documents which we presented. His position is, well, some ratch could occur. Or how could this court find between two countries? This is the first time two countries are fighting each other, fist to fist. How could the court find that wrongdoing occurred on Trinidad and Tobago's side on the basis that it must be so? It probably is so. It can't make no sense. Now, may I just explain something as well? When you look at the quantity of the sugar that at one stage was being touted that came into Trinidad and Tobago illegally, it's 425 tons. That, my lords and my lady, that converts in 50 kilogram bags to 7 million bags of sugar. 7 million bags of sugar. And if you even take their 3,000 declaration in paragraph 118, that converts to 3 million bags of sugar coming into Trinidad and Tobago that came in by virtue of illegality. One would assume if you wanted Trinidad and Tobago to be found guilty in respect of bringing sugar into Trinidad and Tobago for that quantity, that the evidence you would have mounted would have been much more substantial. And may I just say as well, the point was raised, well, what could you do to investigate this? And I forget which one of your lordships or ladyships raised the point. You come to me in 2020 to file a claim about something that occurred in 2018. Where am I going to find the sugar? Sugar is a commodity that what's the word? It's a perishable item. So you can't go back now and check a container. That's in somebody's belly. You can't go looking for that. Now you're looking, what are you looking for? How could that be done? And we have to ask ourselves the question, is every customs organization in the world foolproof? No, there are drugs found every day. There are people trafficked every day in containers. Is it foolproof? It can't be. It's impossible for it to be like that. According to Mr. Huggins, can we examine every container? He can't. And the question is, somebody was asking for this court to give a directive to the customs in Trinidad and Tobago to examine more stuff. That is for Parliament and the government of Trinidad and Tobago. To ask this court to make such a, I think Mr. Marshalleck was saying that's one of the things that could be suggested. That can't be for us at this level. When two governments come against each other at this level, it means that they accuse serious accusations. To move 7 judges to sit to listen to this case, it means that there's an absolutely serious allegation of wrongdoing, which there was. And what has it come down to now? It's come down to supposition, presumption, and the question of it must be so. And the declarations have gone to almost dust. They're asking this court to make a declaration that really, where will that declaration go? What is the court going to declare? That in the year 2019, sugar entered Trinidad and Tobago in breach of article, whatever it is. Somebody reading that judgment, some student in a university or going forward, lawyers reading that, I know this court will not make such a declaration. I can't see how, I spent 12 years at the law school lecturing and tutoring. I can't imagine explaining to students that, you could have a declaratory relief like that. This case, unfortunately, should have never gone off the ground. And that's why I can't remember who it is brought it up, but I have had 2 hours sleep last night, so just forgive me. I can't remember which one of your lordships brought this up, or ladyship. But the question is, we have raised the issue. This really was a case by BSI. I do know and I do appreciate that there was certain relief sought against CARICOM, and I don't know what happened between Belize and CARICOM. I haven't seen any consent order. But this, at the end of the day, and proof in the pudding that the case has fallen is because, one, the 3,000 tons which was suggested came into Trinidad and Tobago, that's gone. 2, it is considered that the documents do not amount to probative value in terms of advancing a case. And 3, it is considered that the goods came in to customs that we showed duties were paid on them. They can't complain. Their complaint is not about price. And I think at one stage, Mr. Justice Jamadar was in this matter, and that I do remember at one of the interlocutory stages. And he asked the question of the other side, what is this case about? What is this case about? And my experience with Justice Jamadar is he cuts to the chase like all the other lordships and my ladyship. But what is this case about? This case is not about a lower price being offered for sugar. And this court must not fall into that realm of saying this case is about what is the price of sugar. This case is about illegality that CET was not charged. CET was not charged, and therefore the articles, the very purpose for which CARICOM was set up and the RTC was set up, is being flouted.
May I ask you a question, please, Mr.
It's not about price. Yes, you may, sir.
Right. Are you conceding that it could have been possible that brown sugar could have, and I use the word advisedly, smuggled into Trinidad without the CET being paid?
So I would answer that question by saying this. Anything is possible. For example, I'm sure all of you have accounts where you buy things on Amazon. How many people present an invoice or not even stay quiet as regards how much they paid and hope that the customs officer passes it?
So I gather then your answer to my question is yes. My second question
But may I just answer that carefully? I want to be careful. My answer to you is, if I may say so, as I said, anything is possible. You could have a body, you could have a person inside of that container. You could have cocaine.
So the answer is yes. Why we need to go around and around and around the mulberry bush? It's not an imputation on Trinidad and Tobago to say that the answer is yes. It's yes for any country in the world.
Precisely. Any country in the world. And that's what I said.
Thank you, Mr. President. So could I ask my second follow-up question? In the circumstances where it was possible that brown sugar could have been smuggled in without the knowledge of the government of Trinidad and Tobago, of course, with the result that CT was not paid on that sugar, are you satisfied that sufficient investigation was done in relation to trying to establish whether that in fact took place?
Sir, I cannot speak from the bar table as I was told just now, but I could tell you something that I spent over...
No, based on the evidence that Trinidad and Tobago, because you see the evidence that has come in has basically been the CET was charged on the sugar that was declared to be extra regional brown sugar coming into Trinidad. And I thought that part of the burden of Mr. Marshalleck's case was that enough had not been done to ascertain whether other sugar had been smuggled into the country. So I'm just asking you, can you point to the evidence which your side has produced to demonstrate the efforts at detection?
So I'll answer you this way, by these words. Remember that what we would have had at any given point in time were proceedings and documents. Let's take that first proposition, that we never had evidence to investigate when the proceedings were filed. We had documents. And I'll repeat the words of Mr. Marshalleck. It is conceded that this documentary evidence is not sufficient of itself of probative value. We accept the quality of the evidence cannot stand on its own. So if you have the documents before you in legal proceedings, which are attached to legal proceedings, where the maker of the document is saying it does not amount to probative value.
But the reason, with respect, Mr. Bharath, and I know like you, many of us are sleep deprived, so I don't want to press the point too much. But the point is that the reason why he's saying that is that the information to substantiate his allegation is peculiarly within the control, so he alleges, of the government of Trinidad and Tobago. So he's saying that having been alerted by the documentary evidence, he was expecting that there would have been some investigation taken place which would demonstrate the falsity or the accuracy of the allegation. And what he's saying further is that the evidence which has been produced by Trinidad does not speak to the efforts of investigation. So I'm just asking you whether you can point us to any evidence that you have given to demonstrate that some efforts have been undertaken to ascertain whether sugar was smuggled into Trinidad.
Right, so could I just answer again? The process by which we come here, this is a court now of original jurisdiction in terms of ascertaining what the respective positions there are. One would not, in a case like this, if an allegation is made against a particular individual or particular country, obviously in settling the witness statement, there would have been investigations. And if I take you to Mr. Huggins' witness statement, he did say what he did in terms of ascertaining whether sugar was paid or not. Remember, when this case first started.
Sorry, can you take us there?
Yeah, when this case first started.
While you're doing that, bear in mind what the president said earlier, that the CT is so very important to the operation of the common market, single market even, that he would have expected, and I think most of us would agree, that Trinidad and Tobago would be very careful and zealous and diligent in the implementation of the CET, making sure that the CET was implemented.
Yes, so sir, can I just answer you again? Remember when this case started, it was documentary evidence on either side. In other words, the only thing we had in this case when it started was document C. and some other documents attached. Subsequent to this case, there were allegations, there were applications made for disclosure on 3 occasions. On the last occasion, one would have thought in the issue with respect to disclosure, that if the court was of the view, the panel was of the view that there was something that we had to answer at that stage, an order would have been made for the production of evidence. We received a ruling after submissions on both sides with respect to disclosure that we were not required to disclose any information to the other side. So the court, the panel of the court that dealt with the interlocutory applications for 3 disclosures, when we answered it by submissions, we were essentially told in effect that we didn't have to give any further information to the other side. So that's my first answer. My second answer, you asked me to go to Huggins' affidavit, Huggins' position, and Huggins' position is at paragraph 13. In response to these proceedings, I caused to be conducted.
Sorry, Mr. Bharath, was that 13 or 30?
The 1313, THRTWN, page 785. In response to these proceedings, and now may I just say who this gentleman is, and may I compare his evidence to the evidence which arises on the other side. He says that this is the Deputy Controller of Customs in Trinidad and Tobago. Right? He says, in response to these proceedings, I caused to be conducted a search of the records of a division through CBSC. Now, CBSC is the Customs Border Control System for records pertaining to the importation of sugar for the years 2018 to 2020. Now, pause in there for a minute. The allegation was in respect of Honduras and Guatemala. Now, may I just say what he did? What he did. The records pertaining to the importation of sugar for the years 2018 to 2020. He didn't give a period. He didn't give 2 countries.
Mr. Bharath, I hear you, but with respect, I'm not sure it's answering what I'm trying to get at. I think that Mr. Marshalleck concedes that. And he said that it is impossible for those records to indicate anything but compliance with the CET. The question is, I'm sorry?
No, sir. I disagree with you because the record.
No. You don't have to disagree with me at all. I'm not saying anything. I'm just saying what he said.
So what I'm saying is, it may be that you may search your records and find that there are infractions. In other words, you may find from 2018 to 2020 that somebody brought sugar into the country without declaring the necessary entry and was charged. So he says he does look through it. In other words, there are systems in the customs, as you would well know, where it would be recorded against an importer that he committed an offense, etc., or didn't import on time. But it does not necessarily follow that he didn't investigate. I don't think this court can find that in the light of this evidence. And may I just say as well, in the end, when Mr. Huggins did his schedule, he certified the accuracy of the schedule. Who has certified the accuracy of anything for Belize? Who?
So you are conceding then that the investigation, if that is the correct word, was confined to a reconnaissance of the records available in the Customs Department.
But where else would they look, my lord? And if you listen to paragraph 19, my thorough, that's the word used, my thorough examination of our records and the table attached as page 3, which is what he was given, clearly shows that Trinidad and Tobago has complied with its obligations pursuant to the RTC and Customs Act, which Mr. Marshalleck agrees with, and has applied the 40% to all extra-regional brown sugar imported into the country, all. I can certify that given the records, I've checked that there were no imports from Guatemala and Honduras from 1st November, which is the dates we were given, to 30th June 2020, and which CET was not applied. I can confirm that. So,
Mr. Bharath, if the allegation is that brown sugar was entering the country, whether disguised as refined white sugar or in containers or packages in which there was supposed to be refined white sugar. And therefore, it was not recorded at all anyway as brown sugar. Would these records assist in any way?
Well, obviously it wouldn't. It wouldn't because, but you could.
Good. All right, stop. Let's go step by step. Obviously, it wouldn't. Isn't that the allegation, or at least a part of the allegation, if not entirety, of Belize?
So, an allegation. So, if I say
that the allegation that Belize has made?
Well, it depends upon what threshold you've reached. So I could make an allegation against you that you have a dead body in your trunk.
Mr. Bharath, I don't understand why you are being so shifty.
Shifty, sir?
This is a yes and no question that is a matter of record.
But
and I can't get a straight answer out of you.
But sometimes you cannot answer straight. You are asking.
But it is a matter of record. Let me answer for you. As a matter of record, that is the allegation that the state of Belize makes.
And okay, and if I say yes,
you want to know what is coming next?
Yeah. So what
Let me tell you what is coming next. Let me tell you what is coming next. What is coming next is that merely to say that your due diligence or your investigation was confined to the records does not address the allegation which is made, because that investigation would only result in a conclusion that does not address the allegation that is made. So it is a useless answer to the question, what investigation, if any, was made? That is all I want to say.
So let's take the answer to the logical conclusion. What investigation can be made? The container is gone, the sugar is gone. Could you explain to me, if I may say so respectfully?
And that is what your response needs to be.
Exactly. If for example, there's a container with brown sugar in it, which went missing, what is the investigation to be made? And when you come to us in 2020...
Let me stop you for a while.
President, may I just say something, please? If you would please allow me. Mr. Bharath, we are not engaged in an argument with you, you know. We are, I think that you may be responding as if we are in somehow trying to argue with you. We are asking questions because these are questions which we think were raised, and we want for the record to get your response. So I'm just suggesting that let's proceed in that spirit.
I'm sorry, President. Add to that, Mr. President, if I may. I think, Mr. Bharath, we all appreciate that, as I said, some of us are sleep deprived for different reasons. So that I think maybe instead of shifty, we should say you're restive, and the lack of full command is quite likely due to the lack of sleep that you and others of us have had. So.
Mr. Bharath, as I said, an answer that says the specific allegation that you have made, Belize, it is impossible now to be able to properly investigate it because, of course, those containers have already gone. They're no longer capable of being searched, but we have put in place XYZ system to cater for your concern as a sister CARICOM country who, like us, is interested, has a tremendous interest in ensuring that each and every one of us implements the CET and the CSME in a proper way. That is the kind of response that I would have expected to hear. But that is not the response I'm hearing.
So could I just say this, Mr. President? You would have seen, for example, from the schedule which you had, the unredacted schedule, and from the declarations which you had, the number of imports that came into Trinidad and Tobago. Trinidad and Tobago has, I guess, and I don't want to give evidence on the article, several importations coming through its borders at any particular point in time in respect of different ports of entry. If you don't have a container number, you don't have a date of entry, you don't have an exporter, you don't have matters of that effect, what is there to investigate? You recall, Mr. President, you have been in this working with us from day one, and you recall how this matter unfolded. We were supposed to come to trial in July, sir. And in July, an application was made for disclosure. And the court graciously said, I will give you an opportunity to disclose. And this was after the witness statements were filed, sir. You were aware of that. And you had graciously said to them, look, I'm going to give you a chance to put your house in order, and we will look at your application for disclosure. By that time, all the witness statements had been filed. All the disclosure had been gone into. So if anything came afterwards, for example, the court disregarded that. What did we, Trinidad and Tobago, have to go on to investigate? And that's why I read to you what Mr. Marshalleck said. His documents does not come up to scratch. So it means to say, if we don't have those key factors, how do we investigate what container? How do we go to the port to find the importer? We don't even have an importer's name. Who committed this offense? You can imagine knocking on San Sucro's door to ask them if they committed an offense 1 year ago by bringing brown sugar into a container. And they ask us what container, what date, what systems do we put in place for this?
So you are saying that you really didn't get enough information to do a proper investigation?
Yeah, and Mr. Justice, would you recall too that we walked this road together from day one? The way this case unfolded is even after we were ready for trial, on the eve of the trial, they asked for more information. Mm-hmm. So if they ask for more information at that stage, what can we investigate? We had already put written statements in.
Okay, that's a point. I just wanted to go back to Article 82 because I look at what is the duty of the member states, that is to establish and maintain a common external tariff. So maintaining a common external tariff, would you agree and that would entail more than just applying the CET when somebody says, okay, I have here brown sugar, so many metric tons. Of course, if that is made known, then you have to impose that CET, that's clear. But does it entail more to maintain the CET? Because you could also, you said, for example, well, it's always possible that some sneaky person slips in brown sugar disguised as something else. That can happen anywhere, and that is true. But for example, if you would have indications that happens more than once, would maintaining the CET also not impose a duty on the state to do something about that, at least trying to prevent that, or if something comes up, to investigate that if there is a proper way of doing that? So that is my question. It's maybe a theoretical question, but it is important. What do you think we should understand by maintaining a CET?
Well, first of all, I think maintaining a CET means that you have a computer, first of all, a legislation which will give rise to the power to collect the CET and implement it. And secondly, there must be a system. The customs gentleman, Mr. Huggins, when he was being cross-examined, he said what the system is. The system, and he went through the system and he said, listen, they're flags. So for example, you may put something into the system and a flag comes in. He says, for example, that the officer in charge can call for the documents. He says that there is a risk part of customs. In other words, that they look, for example, at a particular importer to see if a pattern has evolved. He says that there's also another department in customs that does, for want of a better word, a post-mortem on documents that come in. He says that there are also physical inspections, and he also says we cannot physically inspect everything. Sure. If we see as a court that there are to be systems put in place for other things to be done, then that is going to apply to the, I suppose, the whole economic community, and we don't have evidence of the whole economic community what their particular circumstances are. We do know that I believe it's a standard system that operates throughout the economic community. The question is, has Belize provoked the conscience of the court to suggest that this whole system is bad? This system has existed for I don't know how many years. Legislation has been applied, and it surely isn't only in respect of sugar.
Well, systems should certainly be effective. And if there are clear indications, I say if, then you would expect that something happens. And maybe you agree with that, but you are saying, well, the if didn't happen, so in this particular case.
But also, may I just say so, Mr. Justice Witt? Some of these things are very difficult to police unless you inspect every single container, every single pocket. For example, Piarco Airport, our airport. How many times people have come through there with jewelry that they buy, you know, in Tiffany abroad and don't declare it? How do you search every single person? You come through customs and you see the customs officer makes a decision. Do I let this person through or not? Maybe.
Mr. Bharath, I understand that completely. I started my career in Rotterdam, and I can tell you they have a lot more containers than in many places. So I know exactly how difficult that is. So that is not the point. And I don't think that any one of us is saying, well, you should have a system where it is impossible that things happen. And that is not possible. But on the other hand, we shouldn't be too formal either. We should at least organize our systems such that they can be effective.
So, President, having heard from Mr. Bharath, I think in the full measure and with some assistance from the bench, the indications that there was not more that could have been done to investigate, that customs looked at the documentation and relied upon that documentation to conduct their investigation. I think I'm conscious that we have now taken him an hour and 15 minutes into his address when he, poor thing, had intended to be only 25 to 30 minutes. And since he had only 2 hours sleep last night, I'm thinking that perhaps we are being unduly onerous on him, and we may wish to release him very shortly.
Thank you very much. I should say hallelujah.
Yes, Mr. Bharath. Yes, what else you need to tell us?
If Mr. Bharath is going to say anything more, but I just had 1 or 2 very, very simple questions, Mr. Bharath, I promise you, just arising from your cross-examination with Mr. Martinez, because I was trying to look at it yesterday and to understand it completely. Can I raise them? It's just about a couple, 2 or 3 small things. Yes, thank you, President. Mr. Bharath, you spoke to Mr. Martinez about 16,000 tons. What did that represent, and where do I find that?
Malay, just 1 minute. I have some juniors here who remind me. My head is just... Oh yes, my lady. Somebody had said to us, and I think it's Mr. The second witness set us the
McLaughlin.
16,000 tons was the appetite for the importation of sugar. And when I asked him what period, my lady, he wasn't able to answer.
Yeah, so that is the annual importation of sugar there?
No, it was for a particular period, but he couldn't answer what period it was for.
Okay, because I thought I heard a discussion with you and Mr. Martinez on that. Perhaps I'm mistaken. And then you also looked at Mr. Martinez's table at paragraph 10 of his witness statement. That table came up to 7425.
Yes,
that
lady.
table, I believe, included a period that was not on Annex C.
That's correct.
And I believe Annex C contained information on 3,175 metric tons, is that right? And then the addition to the table came up to 4,250. Those were my calculations. I barely passed maths.
No, milady, if I may, Mr. Martinez produced a table in his witness statement.
That is what I'm looking at.
But
yes.
when you looked at the support for his table, it was missing a number of imports. So he came up with one figure in the table, and his document, which he used to support his table, was much less.
And that document was what? That is what
C. It was his document C, I think it was. Okay. Yes.
So then I am right. That Annex
yes.
C is 3,175.
Correct. He was missing 4,000 tons.
Right. Okay. What I want to ask you, you mentioned and you all said there was a missing 2,000 or 3,000 tons. What is that figure? Where is it missing from? Is it the same table? I'm not sure what.
Yes, my lady. So when you compare the table that he put into his witness statement, in the body of his witness statement,
paragraph 10,
with his annexures, the annexures fell very short of proof in his table. So there was
the annexure, hold on, the annexure is the same Annex C we're speaking about?
No, this RM1.
Isn't RM1 the same thing as Annex C, Mr. Bharath, or am I totally wrong on that?
It was missing. It was missing the balance, my lady. So C2 was missing from Rui Martinez and from Andy, from the government witness. C2 was missing. They only produced C1. They verified C1 and not C2 in their witness statement.
Okay. Okay. So
C2. They missed C2. They missed C2 out.
Okay. And C2 is now found where?
C2 is in the originating application, my lady, after C1.
Okay, thanks. No, I meant, did it get into the witness statement or not?
No, my lady, did not in anybody's witness statement.
Okay. Thank you, President.
Yes. Is there anything else, Mr. Barrow?
No, sir. I have run out of steam.
I thought you would have said you've run out of glucose.
I run out of everything.
Oops. Okay, thank you very much. Mr. Marshalleck, do you have anything to say in?
No, Your Honor. From the discussion, I can see that the court is properly seized of the issues and it's well as a solid grasp of it. And there's nothing useful I can add.
Okay. Well, I need to just thank you both. Thank your assistants. The bench will naturally take time to consider, and we will let you know in due course what our next hearing on this would, when our next hearing on this would be, or whether we have a judgment for you, or as the case may be. Madam Deputy Registrar, would you please adjourn the proceeding?
Thank you, President Saunders. Thank you, Mr. Justice Witt, Mr. Justice Anderson, Madam Justice Rajnauth-Lee, Mr. Justice Barrow, Mr. Justice Burgess, and Mr. Justice Jamadar. Thank you, counsel, your assistants and witnesses, and thank you to the hard-working staff of the Caribbean Court of Justice. Happy Diwali. This court now stands adjourned. Be safe. Thank you.
Thank
you, everybody.
Goodbye.